Michal Bobek. Welcome to Digital Markets Research Hub. You
Thanks so much
represent,
indeed for the invitation.
you are simultaneously a distinguished academic, a former Advocate General of the Court of Justice of the European Union, and also a current Justice at the Czech Supreme Administrative Court. So you know the mechanics of adjudicating, or the process of adjudication in the European Union from the inside. You know it also from more kind of theoretical side as well. And therefore, I think it's really a remarkable opportunity to learn a little bit from your reflection of things. And my first question concerns one of the cornerstones of the setting of the judicial setting in the European Union, preliminary ruling request. We know of the latest reform, and we know about the discussion underpinning these reforms. But we hear rumors. You know the substance. So can you please, and you have published in the Common Market Law Review a voluminous article on this. Please reflect on why the reform was needed, and then the second question will be about the technical side.
Right. Well, thank you. I suspect the reform was simply needed because of the docket, okay, of the amount of cases coming in. I mean, the last time I looked into the judicial statistics of the Court of Justice, it used to be somewhere around 800 to 900 a year at the Court of Justice, out of which there would be 500 to 600 requests for a preliminary ruling. That's quite a lot, okay? And the cases are very diverse and very often complex and deep-reaching, because quite frankly, if it was a straightforward case, not many judges at the national level, including the courts of last instance, which are under the obligation to make a reference, would bother doing so if it was straightforward, okay? So why the reform was needed was, of course, there is only that many hours a day and that much time to think, okay? Then from this point of view, the question is where to go next if one wishes to still have time to deliberate, to think, and to draft properly, and is not really the proverbial production machine for judgment. Now, you mentioned the paper, of course, which I suspect you are mentioning because I was sort of voicing rather critical remarks, or I was rather wondering whether this really is the best way forward, how to face the question of docket. And yes, I mean, look, my guess is as good as anybody's there how the system will unfold, because of course sharing the competence to hear requests for preliminary ruling between the General Court and the Court of Justice is indeed a novelty. It has not been tested before, and there is very variables, okay? How often the case will be delegated, what will be a question purely concerning technical issues, not raising any transversal issues, which is an issue of jurisdiction, how later on often the General Court will dessaisir itself, meaning remit the case to the Court of Justice in the course of procedure, how often there will be the review procedure initiated against judgments of the General Court and so forth. So actually, the estimate nowadays is really open how this will work. I mean, I suspect my critical side was there simply wondering, look, the very essence and authority of request for a preliminary ruling is to have to the potential cacophony of national voices, which might be interpreting the same provision of EU law in a different way, to have one clear voice coming from the center, from Luxembourg, within a reasonable time span, and saying you, this what the law is, okay? That's the very purpose of the entire procedure, and it's legitimizing block. That you get a speedy resolution of a case within a reasonable time, settled authoritatively with one voice. Now, what happens to the very legitimacy of that procedure once you start splitting it up, okay? It's not only one voice. It's more voices suddenly in the room, not only potentially the court and or advocate general, but up to 4 voices if there is a review. So General Court, Advocate General, General Court Judgment, General Court of Justice, Advocate General, Court of Justice Judgment, and the best case scenario, all of it lasting 4 years. Now, you start wondering, okay, so is this really the best way forward, how to face the burden of the Court of Justice? And then, of course, a number of technical issues come next to it, right? Selection of areas, selection of cases. Now, the official explanation is 4 or 5 or 6, depending how you look on excise and whether it's 1 bucket or 2. So areas of law were selected because there is abundance of case law and it's settled. Well, if that's the case, then we don't need really a request for a preliminary ruling if there is an abundance of case law and it's settled, because then in the current procedural setup, it's for the national courts to apply that guidance to individual cases. So are we to create a third category of cases where, okay, there is guidance from the court, but not so much guidance, so please give me a bit more guidance? What's then left for the national court in this structure, okay? I mean, the idea is either it's sufficiently important to be picked up by the Court of Justice, and you need the resolution of either interpretation or validity, or you don't. And if you don't, if it's sufficiently unimportant, why can't it remain at the national level, okay? Why do you have to have the middle layer of less important but still sort of important cases? So these are really the questions which kept popping up in my mind, right? About, sure, you can look at it as a merely quantitative rearrangement of heads of jurisdiction between the 2 courts, okay? Sure. But when you start digging and thinking about the implications, of course, you quickly run into some very onerous questions about where this is supposed to go and why, and the practical operability of it, okay? Because, of course, for instance, the review procedure, how is that supposed to work? I mean, will you be essentially, when there is a review procedure initiated, then you will be suspending the decision of the General Court for the time being? What if then the National Court is happy with the answer already given by the General Court and withdraws the request for a preliminary ruling? Then, of course, the court shall stop the proceedings. Then, even though the thing was subject to review, then what will stand will be the General Court judgment. I don't know. What if it will be only in part? Because, of course, as a review procedure or an appeal works, you can replace only part of the judgment and the rest of it is in force. So here it would mean that the National Court is then to start collating various parts of the judgment of the General Court, of the Court of Justice, in order to get answer to typically several questions it has posed, but only some answers have been subject to examen, and a number of other really questions which simply, I'm not saying it has been badly done, they simply come with the fact that you just split the jurisdiction. The very essence of it is to be unified. I mean, in terms of parallel, think of systems in continental Europe which have specialized concentrated constitutional review before a national constitutional court. In a way, historically, that's how the request for a preliminary ruling came about in the 1950s, where the Italians and the Germans, but especially the Italians, proposed the model to the Rome treaties, right? To have a parallel. Now, would anybody come to the idea that in addition to the constitutional court, we will also have a constitutional court of first instance, which will look at the case first, or specialized constitutional courts of instance, and then it will be appealed through. I mean, the logic of integrated inbuilt procedure here is, well, it's inbuilt into an ongoing national procedure. It's not a lengthy procedure of its own. So on the paper, I mean, the paper is long and I agree complex. I was also trying to make alternative suggestions in the paper, because everybody can be doing sort of the moaning thing of saying, oh, this is wrong, this is wrong, this is wrong. But what is the alternative? And I was trying to explain how it would be possible to conceive really of the jurisdiction of the Court of Justice as really an exclusively indirect one, request for a preliminary ruling from national courts and appeals from the General Court, and correspondingly enlarge the jurisdiction of the General Court to deal with more cases, thereby indirectly alleviating the burden of the Court of Justice on preliminary rulings. You simply start opening up a bit more direct actions and other part of actions which have been closed for 2 decades. And of course, in this way, all the docket comes indirectly to the Court of Justice, even though it could have been heard, especially in complex technical cases, as a direct action before the General Court, would actually be faster and sometimes even better. So look, I'm not saying this is going all down the hill, as just when I looked at the proposal and was wondering about the structural implications of it, I was far from convinced that this is the best way forward for the system.
I wanted to pick a few points from your answer, and the first one concerns the cacophony of national legal regimes and their reading and enforcement of of provisions of EU law. So the nature, can you reflect a little bit on the nature? Do you sense that there is a demand for the unity, or is it kind of creative, a growing pain of cacophony, or is it kind of boycotting cacophony? We know a few examples of kind of pathological situation, but leaving them aside, describing the picture overall, are we moving towards ever closer judicial union, or it's still something so sui generis that is almost undefinable work in progress, where the destination is a kind of moving horizon?
Well, I admit it's rather difficult to address that at such a level of abstraction and generality, because A, the systems are different, they move in different speed in different directions. What you say today with respect of German courts is certainly not the case of Hungarian or Polish courts, and it's not the case of the Spanish ones, okay? They are different errands in the national system, they might be different interests, different directions. On the motivation, on the cacophony, well, depends what you understand by uniformity and at what level of uniformity or at level of abstraction you pinch the demand for uniformity. To me, the system we have in Europe with the preliminary rulings procedure within the EU law has never been about uniformity of outcomes. It's about uniformity, or at least reasonable degree of uniformity in the interpretation of the premisa major, in the interpretation of the law, not necessarily having always the same outcome. Because of course, if you say for you or from whoever, uniformity means that national jurisdictions will reach the same results in similar or comparable cases, that's actually a degree of uniformity which even domestic national systems with high density review are unable to achieve, okay? Take extreme Latin jurisdictions in Europe, such as France or Italy, where the Supreme Courts, or be it, Council of State or Cour de Cassation, would be reviewing tens of thousands of decisions every year in order to achieve their vision of uniformity. I don't know, I'm not able to tell that the degree of uniformity achieved within such a system is comparable to a degree of uniformity achieved in a Germanic system, where the supreme jurisdictions would be deciding, I don't know, thousands of cases a year, and not to speak of English system or Anglo-American system, where you would have a coordinated vision of officialdom, but much stricter vision of precedent, which then, of course, binds the lower courts as to the outcome and might be more efficient than reviewing everything again and again and again. So, long story short, it depends on your vision of uniformity. What do you understand by it and how far you want to go?
I suspect that the answer to the next question will be in the similar modality, which is very, very exceptionally entertaining and joyful to hear. So I'm not searching for the answer, but the train, how you develop them, it's really a luxurious moment. So the role of the preliminary ruling has been portrayed by some authors that historically it has been somehow mobilized by Euro optimists, some lawyers in several founding jurisdictions, and they have been almost tailoring the requests for national judges, so to say. Based on some authors like Tommaso Pavone, ghostwriting, and other people who scrutinize the history of the issue. On the other hand, and we understand the rationale of this work in progress, and then it has been somehow captured by large heavyweight law firms, etc. But on the other hand, we know that judges in the Court of Justice of the European Union have to be focused on the case. So you have to adjudicate on the case, and you cannot consider hypothetical questions. I'm not talking about the procedural aspects, whether it would be acceptable or not. I'm talking about the vision. What underpins the decision, the adjudication process of the judges? The one extreme of tailoring the European law, or another extreme of solving a specific case? Is it deductive or inductive process?
Well, it strongly depends on the individual personality of a given judge, because quite frankly, meaning especially professional background, because what I realized over the years, it's very different how people think juristically based on their profession. If you have been in previous life a law professor, especially in a more, for instance, German or Latin European culture, as opposed to a legal practitioner, whether you have been a diplomat or you have been a civil servant, the thinking about problems is sometimes quite different. And that perhaps, in my experience, predetermines the patterns of thinking more than it does nationality. Okay, but that apart, whether inductive or deductive, it's really both, right? I mean, of course, when you start studying a dossier, a case, then you start first diving into the concrete case. So you really must explore the confines and limits and the space open up by the individual case. And you are there to solve the individual case and the question posed therein. But of course, once you start thinking about giving an answer and providing an answer, you must look broader, okay? And especially if you are at an apex jurisdiction, be it a national one, or you are a fortiori in a court like the Court of Justice of the European Union, where quite frankly, and this will be contested, in my book, your view, your job is primarily not to be solving individual cases in the sense of seeking individual justice on preliminary rulings, but rather answering and enacting the rules in a way they do make sense, they are workable and feasible, okay? And for that, the second part of the equation, you then need to look broader, okay? So you need to look beyond the confines of the individual case and to think not only how this will fit in, but of course also about the implications of what you might be saying, okay? How it will work out in the practice, will it be possible, will it be feasible, what costs, collateral damage, whatsoever it will be causing, and so forth. And then you are, of course, obliged to step outside the confines of one single case and to sort of cross-check or back-check what you are doing more in a systemic framework and systemic impact.
Speaking of the implications, we had last year Vivian Terran here saying that in an ironic way that while the legislative process is being scrutinized by all the co-legislators, in particular by the Commission and the impact assessment and all these studies. However, the merits are, but they do care about to evaluate in a systematic way, whereas the judgments of the Court of Justice of the European Union it's not the job of the court. Again, it's kind of the second part of the same question. So, you don't look at the outcomes. You look at each. So we have currently the big discussion in competition bubbles on the guidelines on exclusionary abuses, where basically the Commission attempts to codify the case law. How does the court perceive such initiative and such need to have some reflections on the systematic performance? Do you do it by adjudicating on the next case, or there are other more systemic, more traditional fashion of doing it?
If you are asking about the impact of the decision and studying and understanding the impact, you make the parallel to the legislative process, okay? So there, of course, impact assessment is normally supposed to be done for each legislation, whether it's the general one or it's the sector one, be it environmental, fiscal impact assessment, and so forth, right? But there, yeah, look, in opposition to a legislator whose job is to create ex ante abstract rules, your job is, as the court, I mean, as a court, including the Court of Justice, is of course to ex post address individual cases. So the logic and the outlook is slightly different. I agree that the Court of Justice is a bit modified by the broader outlook about the implications of the rules, which you clarify and which will be plugged into the pending case, which is pending before the National Judge, which made reference, but of course will immediately be of more broader relevance to all other jurisdictions in Europe. Now, of course, when you are sort of doing a decision, you, I mean, in a judicial, putting a judicial, not a legislative hat on, you try to understand as much as you can the impact of what you will, what it might cause. But of course, I mean, you are within the confines of an individual case, and you have a timeline within which you are supposed to decide, okay? You cannot just push it or kick the can down the road and say, oh yeah, let's wait for the next legislature, right? You are obliged to decide somehow. So from this point of view, you try to gather as much knowledge as you can. And of course, even judges do not live in a social vacuum that they would not understand or see the context or implication. But of course, in the judicial function, your possibilities in that regard are heavily limited. But by the way, I mean, speaking and putting the legislator as the yardstick and etalon, I don't know, perhaps the person you were mentioning that was mentioning that is coming from a jurisdiction where they do these, I mean, from a jurisdiction where the legislative impact assessment is the impeccable analysis of everything, okay? But the legislative impact assessment I have seen, certainly at our small domestic national level, is very often an essay exercise with little or limited data, and the predictions are very difficult to make, even when you run a legislative impact assessment, because, yeah, we don't know. So now somebody might crunch some numbers, but it's an estimate, right? How much different really is that from advised guess of a judge? Then you have a part in a travaux préparatoire, which somebody put together, but I am not able to say heads or tails about it. I'm happy if you are.
Exactly. And well, I'm smiling because it resonates so much with the mindset of economists, who would be very offended even to hear that the economic truth is not discoverable in its totality, and it's not monosemic. The next question.
Yeah, but the problem, if I may, sorry, you just sort of popped that idea in my mind. The problem I have, or what I always wondered about, especially, I mean, in the subdiscipline of competition law, where of course you encounter all these lawyers saying more economic approach, and so forth, and they do beautiful models in order to prove how law is wrong. Sure, but for most part, legal regulation is there in order to twist the behavior, rational economic behavior of undertakings and companies in a different way they would have normally acted. Because if what we wanted to achieve by legal regulation was the same as they would be doing anyway, why bloody would I legislate at all? I mean, I just leave it to the market. So, and then if I always hear, and I heard it a lot, I haven't done many competition cases, but normally general sort of sector regulation, utilities, and a number of other areas where it's always more economic-based analysis and so forth. The answer, the brutish answer of any legislator is, why? I don't care. I want them to do this. And you, as a judge, when you look at this and say, yeah, sure, more economic analysis, terrific. Why bother? Because the legislator said, I want to do this. And unless for compatible with EU law, national constitutional law, you as a judge would be saying, you can't do this, then, well, it's your value choice, which you might or might not be entitled to make, and economic efficiency or utility goes down the drain. Sorry, closing the bracket, just more economic analysis and impact assessment. You started it.
But this mutatis mutandis is also applicable to the next question of human rights, which are also not self-executing, and they need protection precisely because many of them would be harmed otherwise, or affected, or interfered with. And after your description of the judicial of decision-making institutional constellation of judicial authorities in the European Union, we understand that the system is complex in itself. But we have not mentioned another element, significant element, the European Court of Human Rights and their jurisprudence, which also influences the jurisprudence of the Court of Justice of the European Union. Please decode to us the role historically, obviously not giving a lecture. I know you are very time constrained, but to somehow depict the main milestones and where we are now.
Well, I was just about to, you took the question away from me. I was about to ask how many hours have you got, but well, look, of course, fundamental rights are alpha and omega of the discourse we have today, right? And from this point of view, they are ubiquitous, and they do have, or at least in the, how shall I put it, more assertive, robust vision of constitutionality and fundamental rights protection, which developed at the national level, the German Federal Constitutional Court ever since the Second World War, and at the supranational level, the Strasbourg Court, they are everywhere, okay? We get Drittwirkung, we get radiating effects, we get all that. They come into private relationships, horizontal relationships. So from this point of view, they are ubiquitous. And what we can see, what has happened at the national level after the Second World War, was a certain refocalization of the legal discourse. We moved from legality, which was the yardstick, to constitutionality, and the fundamental rights being the core of the constitutionality compliance. So that's really how the system has changed and has been changing massively over the years. And of course, since 2009, where the Charter of Fundamental Rights became a part of binding primary law and EU law, the same, I would say, centripetal effect, sort of sucking in, can be also seen in EU law, okay? I mean, in the first cases in the decade after 2010, it would be very interesting to see the cases, which would be, I mean, sort of the classical, still the classical economic or secondary law interpretation, but then, of course, starting being posed much more frequently alongside or together with compliance with fundamental rights, okay? So then in terms of beautiful charts, it would be really going up of the request for a preliminary ruling involving more questions of the Charter. And very similar type of effect have been or could have been observed in EU law the last 2 decades, okay? More and more questions are partially or wholly put in terms of fundamental rights protection, which of course it's possible and it's necessary. The problem there often is that fundamental rights do not necessarily bring you more clarity in solving technical disputes, which is the bread and butter of EU law interpretation, okay? How to assign international jurisdiction in online label, okay, or disputes, or how to treat a case on trademark. Of course, you can always bring into the game the conflicts between right to privacy and or property and so forth, but it doesn't give you much answer on the technical side of which of the solutions is correct and why. Okay? But of course, that's the fundamental rights discourse is there, it's there to stay, and it's very important to keep the system in check. Now, you mentioned Strasbourg. Of course, that's the key player in fundamental rights protection, setting the minimal etalon for all of Europe, and of course, to which all the domestic but also the EU system are bound. In case of the EU system, there is, of course, the bridge of Article 52.3 of the Charter, which binds the Luxembourg system onto the Strasbourg system. And of course, in reality, it happens quite a lot or very regularly that, of course, one looks when addressing the relevant question of human rights protection, one looks into the Strasbourg case law and, of course, takes it from there.
And I wanted to connect it with the previous one on the role of economics and the role of human rights. If you look at human, you said ubiquitous, some might say pejoratively that we witness some elements of inflation of rights, where pretty much using the vocabulary of kind of brutal legal realists, you can embed any interest or shape any interest in the vocabulary of economics or in the language of economics, efficiency, as well as in the language of human rights. Do you, in course of your legal practicing, do you observe that the heavyweight defendants use human rights kind of as a shield against the procedural imperfections by the enforcers, or indicating some procedural imperfection of enforcers, or this high standard of proof is kind of the reality because the stakes are so high?
I wouldn't perhaps talk of inflation, but of course, you are right that we see a lot of linear expansion. Okay, it is really going in a more expansionist direction, and as we already mentioned before, the discourse has changed. Of course, it's of course about claims and rights. Quite well, funnily enough, the obligations are only on the side of the state or contracting parties, hardly ever on the side of other individuals. Now, of course, is it being misused or abused? Well, sometimes there might be tendencies to, but of course, there you have the judicial power to say, no, my dear fellows, you are going too far. This doesn't fly. Okay. What's more complex is not necessarily instances of abuse, but rather the instances of balancing competing interests on the horizontal level, especially between individuals or undertakings and individuals and so forth, where of course there it moves back and forth with individual preferences, and it's sometimes difficult to predict. Right? But of course the fundamental right, because essentially sooner or later in these type of cases you always end up in some sort of a balancing and proportionality exercise, which quite frankly can go in a number of directions. It's not, I mean, it depends first what type of yardstick you choose. Will it be a sort of just appropriateness or two-pronged proportionality or the strictest three-pronged proportionality, but the German full metal jacket, so to say. If you do that, then of course you are already prejudging the outcome rather heavily in terms of where you are likely to arrive, because not many measures actually do survive the full strictness of three-pronged test of proportionality and so forth. So from this point of view, of course, it's there and it's everywhere. Now, again, when you go back to the Court of Justice, then the past, I mean, the current president, Koen Lenaerts, as well as the previous president, have at several occasions mentioned, I mean, that the Court of Justice is not a human rights court. And they have been really castigated for that statement, saying, oh, no, you do not respect fundamental rights. I think they were very much correct about what they were saying, but it was taken out of context, okay? It's not that the Luxembourg court would not be respecting fundamental rights, very much to the contrary. But again, as I said before, 3/4 or 4/5 of all cases which come before that court are essentially technical disputes where the first layer of the question, certainly, it's a question of interpretation of a provision of Brussels bis regulation, of framework decision on European arrest warrant, and so forth, to which fundamental rights, of course, act as interpretative guidance, as well as the ultimate check on validity and compliance. Of course they do, as in any other national system. But, and this is how the idea was meant, you are not a high human rights court that before you, the cases would come like they come to Strasbourg or national constitutional courts for that matter, where the sashi or the basis of the dispute is compliance with fundamental rights, to which technical questions or other interests might be legitimate limitations. Okay, here simply the structure of cases, or in Luxembourg, the structure of cases is slightly different. But to close on your question, of course, We see it massively, how fundamental rights can bring you to a number of directions which one could have previously not have seen. I mean, just an anecdotal example, recently at the Czech Supreme Administrative Court, I had a case as a reporting judge of a mayor of a small community of north of Moravia, who was the mayor, so meaning the chief executive, I mean the chief officer of a self-administrating unit. So he was essentially a public official, okay, endowed with the powers of public official. But when he was attacking what he thought was incorrect authorization for a paper mill which was built in the village, he wasn't attacking it as a mayor. He was doing it as a physical person because he was also living in the village. And he essentially openly stated, well, look, I did this deliberately because as a physical person with fundamental rights, I can go farther than as a mayor of a village. Which, when you think about it in structural terms, it's already quite telling about the balance. So public official and civil servant, well, I don't get far. As a physical person with fundamental rights, I get much further. And then you start asking, is that sound?
Zooming in, I have a question for zooming out, but I wanted to zoom in a little bit with a caveat though. I wanted to ask you about double jeopardy, non-bis in idem or potential of the Digital Markets Act in Article 102 of the TFEU, with a caveat, which is a very important one. I appreciate how much you have already said and done on this topic. And I wanted to refer to two fantastic, one lecture and one panel discussion. The first one is at a Czech competition day a few years ago, where you engaged with Renato Nazzini and a few other colleagues on this very topic. And yet another one, I think, in the University of Vienna, where you have delivered 1 hour lecture, 1 hour plus, on this very topic. So we will not be discussing the substance. We just refer those who are interested specifically to these two events. They are available on YouTube. People know how to search Michal Bobek. But I wanted to ask you, just rather than asking you technical side of the question, asking you just your crystal ball gazing. Do you think, with the stakes on the DMA being so high and looking at the 102 cases being so complex, do you think this is the destiny of DMA enforcement, that they will be thematized, some elements which appear to be at first glance during the legislative process crystal clear, uncontroversial, and categorically no parking in the no vehicles in the public park stuff, appear to be inertia, kind of hermeneutical once of a sudden when stakes become high. So we will have complex proceeding on the DMA, and will non-bis in idem will be part of it.
I'm afraid I can't only answer half of the issue. Or, well, look, what you mentioned about a non-bis in idem and the lectures, they were essentially a spin-off from the real work done on that in B-Post and Nordzucker, which was one of the last cases where I delivered an opinion, and which concerned, especially B-Post, concerned the question of non-bis in idem in competition or competition and other areas, okay? And then, of course, all that was opened up, and it was a fascinating intellectual journey. I'm not entirely sure with satisfactory results, but it's a different story. However, I'm afraid that on the 102 and DMA, I can't really provide an answer, because being a judge essentially means you are a legal archaeologist, okay? So honestly, I haven't read the DMA. For the simple reason that it will be months or years before I will see a case on that. And from that point of view, if you are a judge, then you are essentially not looking for problems. They are likely to find you in due time. And B, you are archaeologist, because I do interpret and apply law which is months or years old. And that makes you extremely skeptical about reading new stuff, not to say legislative proposals, because very often it's quite frankly just a waste of time, because those proposals, I mean, I'm not saying DMA, but legislative proposals, green papers and so forth, they are bound to change significantly. and there is only 24 hours a day. So, honest disclosure, I haven't read the DMA yet, and I can't really much answer the question, sorry.
Speaking of 24 hours, I wanted also to ask you maybe to share your recommendations about you. You are not searching for problems, but yet I know you being very, very curious, and you read a lot, not only for the purposes of delivering opinions or judgments, but also as an academic. How do you select for those to choose those problems which you search for? How do you filter out? How do you protect yourself from background noise and all this stuff which help you to remain so focused and so sharp and influential in your thinking?
Well, I suspect that they're really, it's not, I don't know what I meant by that. It's a different mindset of an academic whose job it is to be proactively thinking about problems and solving the problems ex ante. I mean, here, really, the yardsticks for me is a German commentary written on a Zigarettenpapier in abbreviations, and very often really just fantasizing about problems, which on the one hand side might seem speculative, unless a couple of years later down the road, somebody looks at it and says, yeah, well, we do have exactly that, okay? So that's what I meant by, in a judicial role, you don't do that. Your mindset is rather the reverse, that if you do have to solve a problem, you do solve it, you can't run away, but you really don't actively hypothesize about the problem. That's not your job. You, in a minimalist fashion, rather try to address the problem which is in front of you. Now, what does one read to do that? Well, rather sadly, that's not often sort of groundbreaking academic treatise. It's really the parties' submissions and previous case law, and sometimes dive into some academic works if they are available and relevant to try to get your head around the problem. So I'm afraid there isn't much of a silver bullet or a miraculous explanation how to do that. It's really, but very often yet again, in a judicial role, you are a reactionary, really. You react to what is brought in front of you. After a while, quite frankly, the acquired wisdom is minimalism. You really don't want to open those cases, boxes, when you really don't have to do them now, because of course, I mean, you are in a danger of savagely overreaching or getting it very wrong. So from that point of view, it's rather more boring than you might anticipate.
Now let me continue this. I wanted just to ask you to visualize how the opinions of Advocate General are crafted. Do you work with how big is the team? How much is divergence? How large is divergence of views? How intellectually stimulating the ping pong is? How many opinions do you hear? Who synthesizes? You synthesizes as Advocate General, of course, but how is it a teamwork, or it's more focused on the personality of each Advocate General?
It depends, yet again. I mean, on the personality of the Advocate General, okay? My take on this was, A, it was definitely a teamwork, and B, I was lucky enough to have a brilliant team. And from this point of view, how we worked, but again, it's personal. It's very personal. Different members work in a different way. But we really work in a way as a chambers, okay? So from this point of view, most of the opinions and most of the questions, which were not easy, would be discussed in a full team and discussed back and forth. And really, I mean, the solution being a collective one. I mean, yeah, I'm not disclosing too much. And if yes, it's only my problem, we would be even running like a chambers, talking as long as convince each other. I think it was only once or twice in 6 years mandate when we would have a hard vote about seeing, I mean, what's the majoritarian view within the chambers. And for me, it was extremely important because, of course, Advocate General is a monocratic institution. And if you take it really at the letter, you are, and you put your personality too strong to the fore with very clear and fixed ideas, then you are also in a beautiful danger of getting it spectacularly wrong. Okay, so for me, it was extremely important to hear the opinions of everybody within the team who was willing to contribute and share their thoughts. And you also start sensing or you're bouncing off your own ideas of others and seeing their reaction, seeing their candid exchange. And from this point of view, it really shapes your own ideas as well. Of course, at the end of the day, there is somebody who must decide, and then it would be the Advocate General. But apart from that, it's very much a teamwork.
You mentioned in your previous answer the paperwork, German commentaries, the paperwork style, where each article is being commented, hypothesized, and scrutinized in detail. And this is kind of specificity of juristic culture, legal theoretical culture, which is very common for Central Europe, I would say. And I remember when moving to Prague, I was really impressed when the Czech Republic was about to join the European Union, how the literature on the EU law, and I should say adjacent disciplines, was booming, and how engaged the discussion was. So I imagine that this is not exclusive phenomenon of Czech. I think similar issue was in Poland as well. I don't know much about other countries. 20 years after this historical accession, do you think, how would you define the role of Central European legal thinking in shaping European legal scholarship?
Well, that's a difficult one. I mean, what you described, my first gut reaction would be as there was so much writing. Yes, because there was money, but that's the cynical part of myself. The more structural explanation is that the Czech legal culture, as well as the Polish, they are essentially intellectual offsprings of the German-Austrian culture, okay? Which to the broader audience might seem rather limited and dogmatic in the sense that it self-describes its primary purpose as systemizing and feeding the legal practice, so to say, okay? So there you do have this close connection between the law as it's being written and the legal practice, and the legal practice looking up to the professoriat, okay? When you go back to Max Weber, you see the classical vision of honorationes, and in the Germanic system, it's always the law professor, okay? In terms of relative height of who shapes the law and who is traditionally important. In the Czech Republic, we perhaps did have a bit of and its other countries in Central East Europe, we had perhaps a bit of a transitional deviation from that model, because in 1990s, early 2000, when you had this hectic time of complete bouleversement of the entire legal system, then simply it takes decades before the legal scholarship catches up. And there you very often would have constitutional courts or courts in general working ex ante from the traditional role of firstly dogmatically to be elaborated and only that, and then applied, okay? There it became reverse. Now, that model, on the one hand side, where you put it at the more broader scale, might be looked at with some disdain, because of course, when you compare such a vision of legal scholarship and its role, then and then compare it especially with the Anglo-American type, where of course work and writing a commentary is beneath us, we are the academics, and the system there is much more self-referential. Academics writing for academics and judges not really caring at all about the production of academia for historical reasons, but sooner or later also for practical reasons. Because working at such a high level of abstraction, which nothing useful to say for the actual application of the law, why would you bother reading it? Okay. So from that point of view, the Central Europe, Eastern European and the Germanic one is very different from the other systems. To your question, what is the role or added value? I don't know. It's very difficult to say. I mean, the European scholarship coming from my part of Europe, perhaps it tends to be more self-restrained, sometimes more skeptical. Okay, skeptical in the sense of, well, not believing anything and everything put on paper. From this point of view, the skeptics towards rules, ideologies, especially broad ideologies, which is then, of course, well, we all know this is on the paper and this is the reality. However, whether I would be able to put my finger down on what exactly has the Center Europe contributed to European legal scholarship, that would be a much more difficult question, okay? Because of course, I mean, you have, it's not one voice, it's a number of individuals, each of them doing different things, speaking with different voices. So it's very difficult to generalize in that way. I was actually thinking about it last year where the 20 years of accession were upon us, and there was this wave of celebration of accession and so forth. And perhaps yet again, my skeptical, cynical self started asking, okay, so a part of this civilizing mission which Europe brought onto us, is there anything we as Central Europe or Czechs have positively contributed? Or are we really just the proverbial money takers and troublemakers, flyover zone, which then is not really worth lending? And I really, so I even had some notes for a lecture somewhere, and it's a difficult topic.
Speaking of lectures, that's the last question. How do you continue interacting with your alma mater, Charles University in Prague? And I was doing my first PhD there as well. I wanted to express my gratitude as opportunity occurs. And maybe your recommendation to academics, how to make their research more, I don't want to say more visible by the Court of Justice, because if your research is meritorious, it will be noted. But yet, maybe you have some observations you would like to share with academics. And the final question will be a recommendation to students.
Yeah. Well, I'm not entirely sure I do have the authority to recommend anything to anybody, but on your first question about the Charles University, sure, I do occasionally teach doctoral students, so it's always great fun to interact, especially with doctoral students, and it's always great fun to teach, especially when you are like I am now at the Supreme Administrative Court, which is a court of cassation, which means the amount of hearings is rather limited. You do most of the work, points of law on the basis of a file. So from that point of view, I mean, the Court of Justice was much greater fun because there were parties to talk to. And most people hate hearings. I love oral hearings. It's actually very instructive. A recommendation to academics, how to be relevant, how to be read. Well, I really don't know. I would very much agree with you that if the thing is relevant, it certainly will be read. But the question is, yet again, what do you understand as relevant and what level of abstraction you put it? Because yet again, to be relevant for the legal practice, it's sort of lower or mid-level of abstraction, okay? It's not the grandest constitutional ideas, but it's normally a practical solution to practical disputes and practical problems. At the Court of Justice, quite frankly, we didn't normally have the problem that there would be abundance of scholarship we couldn't choose from. Normally, we had the reverse problem that on that particular question we were looking for, there was virtually nothing. I mean, sooner or later, we ended up in a sort of an obscure German Zeitschrift für etwas, because there potentially might be something, including VAT law, which, yeah, well, it's only for connoisseur, right? So, but the problem normally wasn't that it would be abundance of scholarship. It's rather that in terms of proactive, constructive thinking, there wouldn't be that much. And the recommendation, how to be read, I mean, I don't know, it's really the question. The problem is, yet again, I'm more and more acutely becoming aware of the culture divides in the perception of the role of legal scholarship. What is it for? And above all, whom is it for? And as I said already before, in this type of Germanic Europe, there is the connection between the scholarship and practice. And there you really can see whether somebody is relevant and to what extent a professor of law is relevant. The problem there is then when I move it to the Anglo-American style of scholarship, there, well, can I judge them on not being relevant for legal practice, if that's the yardstick? Because they never said to themselves to be relevant for legal practice. It's something very different. But on a closing remark here, recommendation, it's simply that, quite frankly, when I read some of the more recent scholarly production, I really start coming back to Max Weber from 1918, I think, Politik als Beruf und Wissenschaft als Beruf, okay, in his series of lectures defining, I mean, it was delivered shortly, I think, towards the end of the war or at the end of the war to aspiring young scholars and politicians. And essentially, it really comes back to me when I read some of the scholarship, which to me, skeptical Central European is deeply ideological and ideologized, and with the ambition of changing the world, right? And you are being evaluated on how much you contributed, what was your impact, how you changed the world, and so forth. And always you look at it and say, well, look, if that's what you want to do, go into politics, do something else. If you want to change the world, why are you an academic? But that, I acknowledge, it's a self-perception of what legal scholarship is supposed to be, at least in my part of Europe, when really it's about knowledge building, not about changing the world and seeking power in it, okay? And that brings me yet again to Max Weber, and I'm afraid nothing is original, everything is repeating itself.
And finally, the recommendation which you would give to, not to parent, but to students. Well, we all in parent yet.
To students, wow, enjoy yourself, don't take it that seriously, that will come later.
Michal Bobek, thank you very much indeed for this really informative, inspirational conversation. It was a real pleasure.
I don't know whether it was informative, but I tried my best.